Committee to order. And I guess the first bill must be 1134 because it's on the podium. And we'll ask the sponsor to come up and introduce herself and the bill.
Thank you, Mr. Chairman and committee members. For the record, I am Representative Diane Power, representing the towns of Brookline, Mason, and Greenville in Hillsborough County, District 36. And I also serve as the chair of the House Municipal and County Government Committee. As prime sponsor, I am here to introduce to you House Bill 1134. This is a straightforward procedural bill to clarify existing law. It does not change anything in law. This bill responds to a number of inquiries that I received this summer before the filing period as a result of House Bill 200 that was enacted into law last year. And additionally, as you may recall, we now have a school district budget cap and a town budget cap. So there was a number of inquiries from both state reps as well as citizens who are interested in these three caps. And they were asking, well, how does this work? So that's the reason that I filed this bill. So the bill has two main goals. And again, to reiterate, it's for procedural clarity. First, this bill clarifies that appropriations accumulate in the order that the warrant articles appear and are taken up at town meeting or as they appear on the official ballot for SB2 and charter towns. What this does is it ensures a transparent running total so that everybody knows when the statutory caps are reached. And second, it ensures consistent rules for when articles trigger a cap override. And it includes proper ballot procedures. So obviously, when the accumulated dollar amounts are going to exceed the cap, the adopted cap, a 3/5 supermajority vote is required to approve that warrant article. Otherwise, simple majority vote applies, notwithstanding certain warrant articles that do require supermajorities. And additionally, at a traditional town meeting, when this accumulated total is going to override the tax cap, at the traditional meeting, the moderator shall use a secret ballot to determine the tax cap override. And again, this bill does not affect the ability for the meeting to reconsider warrant articles at a traditional town meeting. And the other thing that this bill does is it updates the law under SB2 to make clear that some warrant articles do require a 3/5 vote. Under current law, it incorrectly references a majority or a 2/3 vote. Obviously, like I said, we have now the local tax cap, the school district budget cap, and the town budget cap, which the vote to override is 3/5. So in short, this bill makes the existing law both operable and predictable. It's a procedural clarification, and importantly, it upholds the legislative intent of the cap laws, as well as that 10% budget committee rule. And the other thing that I'd like to say is that it prevents inconsistent application of these laws across the state. So I respectfully ask that the committee recommend this bill ought to pass, and that concludes my bill introduction.
Questions from senators? Senator.
Yes, thank you, Representative, for being here. So, specifically, I'm concerned about lines 7 through 9 of your bill. If a warrant article is required to be conducted through a yes/no ballot vote, does that eliminate the ability to bring amendments?
No, it does not. So as you know in law, that there are some types of warrant articles that require a yes/no ballot vote. So obviously, if you're operating under SB2 or a charter, warrant articles appear on the official ballot system, and you vote at town on a town election day. When we are operating under a traditional meeting, like I said, some warrant articles require a paper ballot. So it's yes or no. And importantly, for example, the SAU budget, when you have multi-towns in voting for the SAU budget, it's important that that obviously be voted upon by the different towns underneath SAU. So,
Additional questions? Senator?
Thank you. And I also understand there to be already in statute, which you make reference to here in RSA 3218, sort of a 10%, I guess, excess in total appropriation to be sort of an existing practice. You seem to restate the rule slightly differently here, which I don't know if that's going to create some inconsistency. Could you address that?
so the idea behind that is that the notion that warrant articles accumulate in the order that they appear on the warrant. It's the same type of an application with regards to the 10% rule when you have a different, people call it different things, a municipal budget committee, statutory budget committee, a budget committee, as opposed to a finance committee. So I'm not sure that I see that there's an issue.
So I think the issue is that normally, like, all the articles are voted through and then the total amount of appropriation is assessed against the cap to see if it exceeds by 10%. Your language says when appropriation in a warrant article will exceed the 10%. So combined with sort of the order of voting, doesn't this sort of remove the local control to sort of reassess those spending?
So I have direct experience with the 10% rule because we have in a co-op, we have a budget committee. So what I've seen in my experience for over 30 years is that there's a running total that's maintained by the moderator. And so this operates exceeding, the running total concept is the same for caps as well as the 10% rule.
What's that?
Sure.
Senator Blaine?
Thank you. So I have a couple questions, Mr. Chair. The first one being, is, as I read, talking about the 10% article, the way I read your bill here, budget committees are required to vote on all warrant articles that have financial implications. So within the article in a traditional town meeting, it'll say budget, selectmen vote 3-0, improve this, the budget committee votes 7-0 in favor of this article. Are you saying that the 10% rules, if you take, say, there's 6 warrant articles on there, and the budget committee and the selectmen approve they vote in favor of all of them in the preliminary vote, that's recorded in the town report, that you can't be 10% above that combined number of all the voted articles?
That's correct. With my understanding that the statute says is that a meeting cannot approve spending that's greater than 10% of what the budget committee has recommended.
Okay. Follow-up question. So, different question. I'm going to switch just a little bit. Again, sticking with, we have 6 warrant articles. The first 4 do not require or do not exceed a tax cap or exceed the 10%. However, number 5 and 6, if voted in, would. Does that mean we have to do an individual ballot vote on 5 and 6, separate from everything else, or a 3/5 vote?
That is correct. If you're operating under a traditional town meeting and you have your running total and you see the number in the warrant article that's to be raised and appropriated, if that's going to exceed the tax cap, then yes, that you need to have a 3/5 override vote to approve that spending. And so if you're on a traditional meeting, that is to be done by a paper ballot, which is a secret ballot, yes.
What's that? Okay, seeing no other questions, thank you very much.
Thank you, Mr. Chairman.
Brody?
Thank you, Mr. Chairman, and thank you to the committee for taking my testimony this afternoon. For the record, Brody DeShays, I represent the New Hampshire Municipal Association, and we are opposed to House Bill 1134 as amended by the House. House Bill 1134 would formalize DRA's general practice regarding the 10% limitation and how appropriations accumulate at town meeting, established in RSA 32:18. What is a bit concerning in how 1134 is drafted currently is it doesn't appear to give a traditional town meeting the ability to go back and fix the problem of an over appropriation, which would be done by reconsidering warrant articles and lowering the appropriations of those warrant articles, specifically lines 13 through 15. It says that they shall take the warrant articles up in order as they're presented. And that they'll accumulate in that order. And it's very often we're in smaller municipalities where they start to reach this 10% rule, as Senator Lang asked about and clearly articulated well, that when they hit that 10%, the town meeting decides to start changing priorities, lowering and reconsidering other warrant articles to lower the appropriations. The town meeting needs that flexibility so then they can determine what's best and how much they want to appropriate, but meet the statutory requirements. It would also eliminate the ability of SB2 towns to amend warrant articles at the deliberative session to add contingency language expressing a preference about what happens if multiple articles pass and one of them must be eliminated because of a total appropriations exceed the limit, whether it's the 10% rule or a municipality has adopted a local tax cap. Additionally, it limits the flexibility for towns with tax caps that operate under a traditional annual meeting to ensure that they're setting priorities that meet under their traditional tax cap, where they don't have to trigger these by-ballot votes for every appropriation beyond the tax cap by a yes/no ballot vote at traditional town meeting. And I think Senator Perkin-Quokka's line of questions demonstrates some of the issues that municipalities would deal with, whether SB2, but especially under the traditional annual town meeting. In many ways, would nearly change the form of government for these traditional town meeting towns. And with that, I'd be happy to answer any questions.
Questions from senators? Senator Perkins-Cook.
Yeah, thank you, Chair. So that's one of my concerns is that, like, if this is, and maybe I identified the wrong thing, but to me, removing the ability to amend through these sort of yes/no ballots, like, that's a significant hamstring on these towns' ability to then, reconsider, go back and amend these articles in a way that's much more holistic. Am I reading it wrong, or?
That is our interpretation.
Okay.
Thank you for the question, Senator.
Yeah.
That is also our interpretation and also our key concern. And we think that the DRA's general practice in how they help municipalities implement the 10% rule is currently being adequately abided by. We don't, while this would formalize that practice, and it would formalize aspects of that practice in law, but then go above and beyond, adding additional requirements onto the town meeting and limitations. Additionally, Romans 1 and 2 of Section 1 are redundant. Those are effectively restating existing statutes.
Representative Power, why don't you come up and sit there at the end with the microphone, because there's only the two of you. And I think that there's questions that have been generated here that only you can answer. So we'll keep both of you up here testifying at the same time. Right?
Okay.
A little deviation from what, no, sit right there. And then you have your own microphone. You don't have to share or anything. I wanted to give you the opportunity. You were shaking your head no on some of the issues there. So I wanted to make sure that you could respond, and then we'll do just a little bit of back and forth because I want to get through this.
Thank you, Mr. Chairman. So as I stated, that this is just to provide procedural clarity. The intent of this bill is to provide guidance so that when we are dealing with any type of a cap and the need to override it, that there's clarity and consistency in the application of the law across the state. My concern is, as I've seen in my own firsthand experience, that laws that we work very hard to pass and to enact, they're simply not followed. And as I said, we have the local tax cap and the budget caps, and that there was confusion and misunderstanding, and So that's the purpose of this bill. It's not to change anything or break things. So just to be clear, I have heard and I continue to hear that this bill that's before you is going to restrict the ability for a meeting to reconsider articles. That is not my intent, and frankly, I don't see that in the bill as written. At a traditional town meeting, the meeting does have the authority to go back and reconsider articles. It's their meeting. So I'm not sure where that confusion is coming from.
Senator Lang has a question?
Well, Paul, I just want to make sure I understand what she said. So again, it's been my experience as a moderator the last 15 years that, number one, we can adjust warrant article position in an article at the day of the meeting at any time we want. We want to take article number 6 and move it to article number 2. We can either vote, or generally I do it as a moderator. You know, we're going to take this up unless there's an objection, and most times there's not. So I don't think we lose the ability to prioritize warrant articles. I think the question comes down to the ability to, once you've voted on an article, is that, and all of a sudden, I said, we use the argument of 1 through 4 does not touch the cap. Number 5 now starts touching the cap. Can we go back and undo a vote on the third article and say, you know what, we're going to say that 5 is more important than 3. We want to reconsider the vote on 3, vote down number 3, and now number 5 doesn't need a ballot vote. Does yours allow that to happen? Because
I believe that yes, that can happen. The main emphasis is that as you work through the warrant in terms of overriding the tax cap, that the warrant articles as they're taken up, that's how you deal with the running total in order to determine if you need to meet that 3/5 supermajority to override the cap. My intention wasn't to tie a meeting's hands to go back and reconsider. When I was contacted by a state rep who was inquiring on behalf of their moderator, he was asking, after the meeting's all adjourned, they were going to go back and rearrange warrant articles. It just, there was a lot of confusion, so my hope was that this would clarify and make things very clear. So I hope that answers your question.
All right. I'll get to you in just a second.
Yes,
It
Senator.
depends certainly if the town meeting is operating under Robert's rules. And Robert's rules does have provisions where you can go back and reconsider something, would take a vote. Certainly one of the issues why I want you both up here is that the order of those warrant articles becomes very important when I know that one of them or several of them are going to exceed that tax cap. And the ability to, set that order either by the people who are at that town meeting or through the moderator is a certain prime concern to me. So Brody, I told you I'd let you speak. There you go.
Thank you, Senator. So first, I just want to clarify, most municipalities, their traditional town meeting or the moderator typically don't use Robert's Rules of Order because they're pretty large and unwieldy. They'll have their own adopted local rules of order that align with state law, which obviously would include, motions for reconsideration. Our key concerns, again, are in line 13 through 15, where it says, total appropriations in warrant articles approved by the legislative body shall accumulate in the order in which the warrant articles are taken up at the annual meeting. Where it says they shall accumulate in the order they are taken up, our interpretation is that has some kind of limitation on being able to reconsider. And we flagged this on the House side, our concerns with that language seems a little bit too stringent. We understand the intent. The overall intent of this bill is not a wholly bad idea. And it's also, not out of line with what DRA is currently advising municipalities to do. But what we need to make sure is that we're not placing unreasonable limitations on the legislative body to determine how they want to prioritize spending needs within these either locally adopted tax caps or other statutory requirements. We also have some concerns on lines 17 through 18, where again, it says shall accumulate in the order in which the warrant articles are approved at an annual meeting. We think there should be a little bit of clarity regarding deliberative session order and how they change at the deliberative session. So
All right, I think that we've gone as far as we can on this one for right now. Unless the senators have anything different, right now, we have 5 in support online, 42 opposed, and we're going to close this public hearing, and we'll start the next one as soon as I get back.
thank you, Senator.
I'm gonna start it up. Do you want me to go? Take as vice chair, take over the next bill?
Sure.
Yeah, the sign sheet for next bill.
You got the sign sheet?
Is that it? Okay. We'll get and open a public hearing on House Bill 1135. And is one of the prime sponsors or other sponsors available? On it.
Good afternoon, Senators. For the record, my name is Deborah Elward, and I represent Merrimack District 5, which is the towns of Andover, Danbury, Hill, Salisbury, and Webster. I'm here to introduce House Bill 1135 as amended regarding limitations on adverse possession and prescriptive use of private roads, trails, and ways. This bill came by way of a gentleman in Sandwich, New Hampshire, and he went to his rep, and his rep didn't know what to do with his request. He was seatmates with a gentleman who is the co-sponsor, and knowing that I live on a private road and that I have knowledge of private road law, the bill idea landed in my lap. So the bill was crafted with the assistance of a private road litigator, and it got its way through committee, passed 17-0 on the consent calendar. This law is a protection of private property, and that should be afforded to private property owners because existing law has long prohibited the acquisition of public property by adverse possession or prescription. And we are simply affording the same protection to private property owners. That law is 477:34, property. So here the public land is protected from loss by adverse use. So the bill raises a simple and important policy question. If New Hampshire law protects public property from being taken through adverse or prescriptive use, should commonly held private roads and trails owned by multiple private citizens receive similar protection? This bill seeks to ensure that shared private access ways are not lost through adverse possession or prescriptive claims, thereby preserving access, stability of title, and fairness among co-owners. So in the 11th hour, I received a massive memo from a property law attorney at 9:30 this morning. So within the half hour I had, I contacted the private road litigator and supplied him with the memo. He has the memo. And quite frankly, I have come to learn that there are several individuals behind me who are in opposition, but I haven't had the time to understand what their opposition is. And I just want this committee to know that this is not a theoretical situation. I have personal experience with a situation involving a privately owned road where one individual began asserting control over a portion of that road and restricting access to the other lawful co-owners. So situations like this can quickly become contentious, expensive, sometimes violent or worse, because the laws surrounding adverse possession and prescriptive claims can be complex and uncertain. This bill seeks to remove that uncertainty by making clear that private roads and trails cannot be converted into private claims simply through unauthorized use. In fact, in the news here recently, the governor of Pennsylvania made the news by attempting adverse possession of a neighbor's property and using the state police to block the property owner's access. So I find it ironic that this bill landed in my lap, and it tells me that there are, well, over the years, I have interviewed lots of people on private roads, and they've told me of the shenanigans regarding adverse possession and prescriptive use. So I gave the committee a handout, and I have to make a correction. It says that the bill had the support of the New Hampshire Farm Bureau, the New Hampshire Association of Realtors, and the Timberland Owners Associations, which told me today they're withdrawing their support, but I'm not quite sure as to the reasons why. The goal of this bill is simply to prevent future opportunist claims, but not to disturb settled property rights. And I'm understanding that making a slight amendment to line 18, instead of using this action will not apply to any claims already fully adjudicated.
That's not line 18 on the copy.
On the amendment? Oh, that's the House bill. I'm sorry. I'm sorry. It would be 3 application,
Okay, 16.
the last sentence.
On 16 and 17 is
So,
section
okay,
3.
line 16. So instead of using this act shall not apply to any claims already fully adjudicated, it could read or should read fully ripened.
We'll take that into consideration. Anything else?
I have handed out a point-by-point rebuttal to Mr. Stephen Nix's testimony, and I can hopefully speak to any questions.
Certainly the senators, if they have questions, they'll ask them now. And if they have questions in the future, we know how to get a hold of you.
Oh, thank you.
Questions from the senators? Seeing none, thank you very much. Dennis. Come on up.
Good afternoon. Thank you for the opportunity to address you and for your service to the citizens of New Hampshire. My name's Dennis McKenney. I am a landowner of about 100 acres, some of which serves my house. Other is traditional timberland in Bennington, New Hampshire, which is in northern Hillsborough County. I happen also to be a land surveyor for 39 years now. And I'm here to encourage you to find this bill as written inexpedient to legislate for the following reasons. It proposes to remove longstanding, time-tested, and judicially honored common law principles. In fact, any plan that I produce as a land surveyor in New Hampshire, I am required by our rules to show lines of possession and any observed evidence of unwritten interests on the property. And this reference text that many surveyors rely on happens to be copyrighted 96 years ago. It devotes more than 80 pages to the concept of the transfer of rights and property by unwritten methods, as the methods proposed here for Sunset are listed. I regularly serve as an expert witness in boundary dispute matters, and I rely on these common law principles and the decisions of the New Hampshire Supreme Court, which also from time to time references these same principles when boundary disputes make it to that level of the judicial system. Property disputes are typically very nuanced and very site-specific and often very owner-specific. Property is as unique as the individuals that presently own it and those that have come before. I think it's very dangerous to try and craft a one-size-fits-all bill to address these very unique problems. So I think the bill as written is quite hostile to the protection of private property rights. Thank you very much.
Questions from the senators? Senator?
Yes, thank you for being here. So as I read it on a going forward basis, this language would prevent both an easement arising from sort of regular use by someone, to access like a beach, for example, or a hiking trail, but it would also prevent rights arising through adverse possession, so both permissive use and non-permissive use.
Correct. It's also retrospective in the way it's written.
I agree.
So long-standing uses would be terminated by the language in the bill as I read it.
So just to clarify that question, if I may, Chair.
Absolutely.
There are specific carve-outs here, but none of them sort of seek to address easements that have arisen by law over time.
I think they propose to sunset those easements and terminate what rights people may have already established by long-time use. And I think that's hostile to the concept of private property rights. And again, these situations are often very complex and very site-specific and very unique. And I think you've got a proposal here to generate a one-size-fits-all solution. And those typically are never particularly good.
Thank you. Thank you.
Question, is there a situation out there that does need some legislative action?
I don't have any particular example that I can provide you.
Okay, thank you. Seeing no other questions, Stephen? The first names on the list are usually much easier to read than the last name, so.
Thank you very much. My name is Stephen Nix. I'm an attorney and a land surveyor. Been an attorney for 26 years and a land surveyor for 40. And the chairman will also appreciate that I too am a 1978 graduate at University of New Hampshire. I was
All
at the Wisby School though.
I may have been a little older than you when we graduated.
I was on the 4-year program, so I've made it right through.
And I went to the University of Southeast Asia Zion, Vietnam campus first.
Thank you for your service, sir. You were probably there with my dad. But, I did submit a lengthy memorandum, which I will not, you'll be happy to know I'm not going to read it verbatim. I'll hit the highlights.
I'm not sure the chair would let you.
Dennis has already hit some of the issues.
Senate rules discourage you from reading testimony that you can submit. And they also discourage you from repeating things that have already been said.
I will follow the rules to the best of my ability, Mr. Chairman. In response to the Representative Alward's testimony, she indicated that this bill, that the intent of this bill is to protect private property rights, but when you apply the rules of statutory construction, and in this particular case, just read it and apply common language to it, this actually eliminates private property rights. So whether the intent, or in other words, the language that's on the page does not reach the intent. I read Mr. Obrick's testimony from the House and regarding the proposed need for this, and I think that the chairman's question was on point to Dennis, is that do we really need something? I think that's the first conversation that we need to have, is do we really need legislation? Maybe, I don't know what the answer to that is. I just found out about this at the end of last week and spent most of the weekend trying to figure it out. Easements, generally, there's 3 ways to create an easement. And by the way, an easement is the right to use somebody's land, not the ownership of the land, just a right to use. And in this case, we're just talking about roads and trails. And easements are either by written conveyance, by prescription, or by implication. The proposal as written would eliminate prescription and implication. The word is used in there. Easements by prescription and there is some confusion the way that the bill is written as well. There's a difference between a prescriptive right, which is an easement, and adverse possession, which is when somebody takes the whole property or uses the whole property. I'm just going to focus on prescription, which the elements are 20 years of adverse use, continuous, and to give the record owner notice. So in other words, the owner has to know, and this has to be going on for 20 years continuously. Each one of these cases is highly, highly fact specific. When it goes to litigation, the court is listening to the facts and determining whether the elements have been met. Some people think it's confusing, but when you read the hundreds of cases that is behind this law, again, as Dennis had said, there's 80 pages just to the treatise, but there's hundreds of cases out there. The practitioner gets an idea of what prescription is. An implied easement, and what I'm going to do is I'm going to go right to my examples. The implied easement is when there is in this particular case, the best example is when there's a subdivision plan, say from it could be the 60s or the 70s, and the deed simply says that you're going to get lot 5 off the subdivision plan, and there's a road shown on the plan, but the deed doesn't say anything about the road. There's an implied easement that arises at the time of the deed that the lot owner can use the road. This legislation would eliminate that. And you can sort of see where the problems arise. I did email all of the members of the committee, and I understand everyone's pretty busy, and I just went out yesterday, so I don't know who's read what. But what I did was I put together the 2 scenarios. There was a recent Supreme Court case in Molten Borough, the Martin case, which talked about the implied easements. It's the exact scenario I just told you, and here's the plan. Lot 3 was sold off the plan, and it didn't give any rights in Park Lane. And so the people who went, and the Park Lane is a private road, and somebody or an association ended up owning the road. And if you read between the lines, there was some conflict between the owner of Lot 3 and the association. The association said, you don't have a right to use the road. And the court said, of course they do. That's the implied easement. That's 200 years of law. This House bill would eliminate that and would essentially create Lot 3 as a landlocked parcel of property, because they would have no recourse at all under the statute. The other example, and I know this is a little hard to see, but This is the lakefront lot scenario, where the lake's on the bottom, and the owner of Lot A over here was a farmer back in the 1920s and started to convey off, I'm going to make this up a little bit, but convey off fishing camp lots. You see this all over the Lakes region. And the fishing camp lots were just sold off by meets and bounds. The farmer drafted his own deeds. Never said anything about the little camp road that went behind, but that's how everybody got to their lots for 100 years. The family of the farmer sold Lot A and all the backland, and you see the road is on Lot A. And the people who bought it decided that they wanted to have a family compound and wanted to close the road. And the owners of the camp lots could go to court. Not that anybody wants to do that. It's not the best experience for anyone, I can tell you that. But they would go to court and they could claim prescriptive rights as well as possibly an applied right. This legislation would eliminate the camp lot's ability to bring that lawsuit, and those lots would become landlocked. Because of the way that the legislation is currently drafted, I believe that it's unconstitutional, because the rights in those roads, especially in the implied easement, that right attached to the lot the moment the lot was sold. So it could have been 10 years ago or 5 years ago. And the way it's written, it says that anything that is not adjudicated is eliminated. So that private property, this as it's written, would eliminate that private property right. There is a suggestion for an amendment. I just heard it. I'm not sure whether that would solve the unconstitutional problem or not. You really have to take time and look at these things. With that,
I think Senator Perkins Croker has a question.
If you're ready.
I am ready.
Okay. It seems like the origin of this legislation is that we've got all these like avid hikers with their Apple Watch running through someone's yard to climb a mountain or something. I mean, under the doctrine of adverse possession, the easement that would arise is personal, right? So that same individual would have to demonstrate 20 years of continuous adverse use in order for an easement to arise.
That's correct. And there could be a solution, and I'm not saying that we could do this immediately, but there could be a solution in the Fish and Game statute. And I'll give you an example. In the Fish and Game statute right now, if the landowner allows people to hunt, or doesn't post the land, let me put it that way, and allows people to go through and hunt, they are not liable for any activity, any recreational activity. One possible solution would be to look at and craft a bill that's very narrow that says if you're not posting your land and people are simply walking through for recreational purposes, that they cannot then claim the adverse use. But we really need to study this and figure out what the problem is, how big it is, and then what the ultimate solution is.
Thank you.
Additional questions? Senator Lang and then Senator Rutherford.
Thank you, Attorney Nix. Thanks for taking my question. So being the senator from the Lakes region, this concerns me a lot because we have a lot of private roads along our lakes that have developments behind them that are private roads. And so as I read this bill, it's possible that if there wasn't a conveyed easement in the deed and it goes across somebody's corner of a property, and the road goes to connect to another 10 houses down the road, if this were to pass, that person can go put barricades on the end of that road that's on his property and just block access to that road completely, and everybody have access to their property?
That's correct.
Thank you.
Senator Rutherford.
Along the same lines, so the example that you gave for implied easements is something that has been explained to me through my attorney, because I represent the North Country, and he said, every little lake and pond up here has these little roads that go around it, and they were done 100 years ago. And so the question I had, well, who owns the road? And he said, well, everybody owns the road, because it's been there for 100 years. And if I'm interpreting this right, that's the implied easement is really where we're getting at. And to pick up on Senator Lang's question, if the law were to pass, this would could dramatically change the character of our little lakes and ponds that have had fishing camps on it for 100 years.
Absolutely. Yeah, many of the lots would become landlocked and there'd be litigation ongoing.
Thank you.
Additional questions? Seeing none, thank you very much.
Thank you very much.
Thomas, Lacy? Says it gets harder as you go along because you can't repeat, You can say, I agree with.
I couldn't repeat what some of these folks, knowledgeable folks say anyway. Chairman Gray, distinguished committee members, my name's Thomas Lacy. I'm from Keene. I'm a landowner. I have 65 acres. And I testify in opposition to House Bill 1135. This bill is unnecessary and will be damaging to an untold number of property owners. Testimony in the House clearly suggested that technology and the use of social media is driving this bill. Somebody mentioned the Apple Watches and the apps that folks now have, and they say, oh, there's a trail there or a road there, and everybody starts using it, and they're worried about adverse claims as a result of that. And this is, in my opinion, this is not a good reason to throw away the rules of common law, which have been around for hundreds of years. Technology has learned to adjust. I live at the end of a dead-end road. My private road starts at the end of the town road and runs for over 2,000 feet. It used to be a town road, but was thrown up in 1923, making it private. Here's the problem. Since the beginning of car GPS, my private road has been shown on all the GPS databases as being a public road. In fact, a nice shortcut from Route 9 in Keene to Route 10 in Swansea. Many, many strange cars regularly turned around in our driveway. The city said, it's your problem. Faulty web mapping also caused folks looking for the local nature preserve to come to our house thinking it was a trailhead. And social media told Keene State College students that our private road was the location of a popular swimming and partying spot. So we were challenged from all directions, basically by technology. ATVs from the south, automobile travelers from the north, local folks looking for the nature preserve, and college kids looking for the swimming hole. Our solutions. We maintain a gate and a rock barrier at the ends of the private road. We reported the mapping issue to the GPS providers. We put up signs at both ends of the road indicating that it is private. I met with the nature preserve staff and suggested directional signage, which they implemented. And after years of trying, we were able to get Google to revise their maps, although my road still appears on many web maps. The result, GPS has gotten smarter, learning that it's a dead end. Very few people come to my house thinking it's a trailhead. Kids looking for the swimming hole are now guided to the right location. And the point here is I asserted my rights. By asserting my rights, the world has learned it's not a public pass-through, but it was my responsibility as a landowner to deal with it. And I feel that it's the responsibility of all property owners, whether it's part of a subdivision or to when you think that there's encroachment happening for you to deal with it. And that's really my point, is that these are solvable and there's no reason to throw out common law to solve which may be just temporary problems. Thank you.
Thank you. Questions from senators? Seeing none, thank you very much. Mr. Johnson, I'm going to take you now because you're a supporter. Oh, he said he's not speaking. All right. Sorry about that. Jason? You're next on the list. That way.
All right. Thank you. For the record, I'm Jason Stock. I'm the Executive Director of the New Hampshire Timberland Owners Association. And coming around is a letter of testimony from Wagner Forest Management, one of our members, in opposition to House Bill 1135. We originally thought this was a good bill. We looked at it in the context of a landowner saying, hey, no more adverse possession, no more prescriptive rights being thrust upon us. And so our initial look at it and our initial position was, this is a good bill. This is something that supports it, or we would support. And it went through the House, as you heard, and then I had a number of members contact me and said, whoa, wait a minute. And then they came forward to me with many of the types of stories that you've heard today. Instances where instead of a beach, lakefront property, it's a sugar bush. I've been crossing a neighbor's property for years to access, or my family's been crossing a neighbor's property for generations or years to access a sugar bush. And this, ownership changes. Well, this bill, my ability to, under prescriptive rights, would be extinguished. This bill would extinguish it. Likewise, access roads for timber cutting. As Senator Rochford had mentioned, his district especially is home to many, many, many miles of private roads. A lot of the large tracts of land have timber roads across them that are all private, and those are maintained by the landowner, but other companies will use those roads to access their parcel that may be several miles down the road. Likewise, you have camp owners. And so once we had kind of called an emergency policy committee meeting, and I said, all right, House Bill 1135, I'm hearing feedback from our members. We need to have a conversation. Originally, we thought it was supportive. What do you think? And I got kind of an earful like you're getting today, all these examples of where it could create problems for land management, accessing, kind of upsetting some of the traditional access arrangements, would be at a camp lot, neighbor to neighbor. And so for that reason, we do come today in opposition to the bill. I have not, the proposed amendment, again, I had just learned about that today, and we would have to certainly take a look at that. But I think as the bill as proposed, we come in opposition to it. We do think that, you're upsetting common law, that's been on the books for centuries because of a single instance. And as you heard today from some of the prior testimony, it sounds like there are other mechanisms to address that particular issue. With that, I'll be.
Questions from the senators?
Thank you.
Seeing none, thank you very much.
Thank you.
Mark? Remember, you can't just say I agree and thank you very much.
I will be brief. I agree with many of the previous testimonies, and I am in opposition of this bill. For the record, my name is Mark Kondo Demitraki. I'm a resident of Laconia. I own over 200 acres of land in the Lakes Region area, but I also own an urban parcel of land in downtown Laconia. And I just want to give a brief example of how broad and wide-ranging the language of this bill is. I own a commercial property at the corner of Main Street and Canal Street that was built in 1925. My direct abutter, his property was built in 1890. There is an alley that separates the two structures. The alley is no more than 100 feet long. My building was built obviously 30 years after his. And yet all of the egress, all of the access, all of the utilities are only accessible through that alley. That alley is fully on the property of the abutter. It had been used openly and notoriously for almost 100 years until the abutter decided that they wanted to exercise their rights to block that area and prevent access to not only our property, but another property that was a beneficiary of this alley. We offered to buy an easement. We asked for permission to use, all of which was rebuffed. We had to go through prescriptive litigation. We prevailed. And I will say to this committee, it is an extremely high bar to achieve. This is not something that courts are handing out like M&Ms. There is an extremely high bar that you must meet to achieve those prescriptive rights. And we've talked about, and the previous people have talked about the implications of large tracts of land and waterfront lots, etc. There are thousands of properties in the state of New Hampshire in the exact same position that I was in. And this bill would effectively allow those landowners to block alleyways, block driveways that have for 100 years served multiple buildings and properties. And that's obviously a significant impact. So
All right, without objection, I'm going to go to the senators because
and I'm all done.
questions from the senators. Okay,
Thank
thank you
you.
very much. All right, that's the last person that I have. The online signups were 3 in support, 1 opposed. And with that, close the public hearing. We'll open the next one in just a minute. Come here and take these over to Jessica, please. Thank you. Okay, let me just close this stuff up. And our next bill is House Bill 1233. And prime sponsor, I don't see him, so
Mr. Chair, I'd like to introduce House Bill 1233 relative to the minutes of non-public session.
thank you. Sir?
Good afternoon. My name is Sarah Burke-Cohen. I represent the New Hampshire Municipal Association. I will keep this very short. The New Hampshire Municipal Association opposes this bill. We believe its language is redundant and duplicative of the language already in 91A. 91A already requires you to, if in going into non-public session, to do a motion on why you're going into non-public session specifically. And the statute already outlines that you should only be covering in non-public session what you've moved to go into non-public session about. So we believe this language in 91A 3.3 is redundant of language already in the statute.
Questions from senators? Yep.
Thank you, Mr. Chairman, and thank you for your testimony. So I've heard some about this bill. It came from one of my constituents in Littleton, and I think there's a concern that, things are being talked about in non-public that they just didn't know what was in non-public. So it sounds to me and I'm familiar with what is it, 4 reasons that you can go into non-public. So it sounds like perhaps if there's a question or a problem with a public body going into non-public, and the reasons why, perhaps they should file a formal complaint, maybe with, I don't know, would it be with the Attorney General's office? I don't,
Would have been with the ombudsman, right to know ombudsman, but that person is, that
Okay.
position's vacant currently.
so let's just say it's the Attorney General's. I
It
don't
is, I
know.
believe now.
So that would probably resolve some of the concerns as a reason the bill came about.
I believe so.
Perhaps. Okay. Now, the other part of it is just the time, start time and end time. Do you have any problem with that?
Not really. I mean, I think that many boards are already putting that in generally. Some of them, I'm not saying some of the ones I've been members of have put start, hey, we're going into non-public at this time. We came back at this time. I don't have the NHMA wouldn't have a problem with that, just as we didn't have a problem with it being recorded in the minutes. I think there was a bill passed last year.
Well, and if I may follow up, Mr. Chairman.
Certainly.
And I think, another constituent or another concern that I heard about this was not necessarily with our municipalities, but maybe some professional boards. There's a concern that maybe there's a lot more business being done in non-public than what is stated. So, they suggest if we had a start time and end time, if it was an easy issue declared in the purpose for going into non-public and it takes 3 hours, it may not add up. So,
I hear what you're saying. I did hear that testimony at the House committee about timing and having that concern of, well, if non-public's this long and this long, like, how does it make sense if they just were going into non-public for one vote and it took 6 hours? So I hear you on that. Again, I don't think we'd object to having a start and end time to non-public session, but the other language is duplicative. I certainly can point out to you where it says that you should only be go into non-public specifically for what you're talking about. And I'm sorry.
I'm familiar with
Okay.
that. Yes. Yeah, thank you.
Senator Lang.
So I guess I'm reading that start and end time differently. It doesn't require that when they move to go into non-public session, they estimate how long they're going to be in there. What that says is that the town will keep a list of all the non-public sessions, and in that list, they must say that on this date, they went in non-public session, and this is the start time they went in, this is the end time they come out, and they have to maintain that list. That's all that provision does, is say on that list, it shows the start and end time must be included.
And now that my brain has caught up to what you're talking about, I actually remember that as part of an issue. This seems to be misplaced. And I think if they wanted to have the start and end time, just like they put the start and end time into public meeting minutes last year, I don't think this is exactly the place, because I do agree that this could be just that list of, hey, here are non-public meeting minutes for whatever, March 18th, 2026. And this non-public meeting went from 6 to 7. I think that is the list. I think the hope is that they would put it on the meeting minutes itself, but I agree. I'm not sure this is the right location for that.
Additional questions? Seeing none, thank you very much. Anybody that signed up that said they weren't speaking, change their mind? Yeah. Okay. All right, with that, there were 5 in support and 1 opposed on the online signups, and we'll close that public hearing. Open the next one in just a minute. Okay, and with that, we will open the public hearing on House Bill 1369. And do we have anybody here to introduce the bill?
Mr. Chair,
Set the
seeing
line.
nobody, I introduce House Bill 1369 relative to the manner of posting the warrant for special town meeting.
Okay, thank you. All right, Brody, I guess you're the first one on the list.
Thank you, Mr. Chairman, and thank you, the committee, for taking my testimony this afternoon. Again, for the record, my name is Brody DeShays. I represent the New Hampshire Municipal Association, and we are opposed to House Bill 1369 as amended by the House. So the original bill permitted the selectmen to post a warrant for a special town meeting in either a newspaper of general circulation, which is the current requirement under statute, or on the town's website. So this is specific just to special town meetings. With fewer newspapers in general circulation in many municipalities are moving to digital formats, and most newspapers requiring an online subscription to read them, most people go directly to the town's website or to town hall to see when meetings or public hearings are happening. It's free and easily accessible if the municipality operates a website. Some don't, but the vast majority do. Additionally, people are more likely to post on social media to raise awareness about public meetings and hearings they find important, including special town meetings. And an increasing number of Americans receive most of their news from social media. I'm not saying that's a good or a bad thing, but that is the way people now receive their news primarily. House Bill 1369, as amended by the House, requires that towns that maintain a website to post the warrant for a special meeting on the website and in a newspaper of general circulation, which is an additional posting requirement. It would seem most prudent to require posting of the warrant on the town's website for a special meeting and allow municipalities to choose whether to post the warrant for special meetings and regular annual meetings in a newspaper. For regular annual meetings, the posting requirement is just two public places, one where the meeting's going to happen and another public place. Only special town meetings require the newspaper posting when it comes to a meeting where the legislative body is acting on warrant articles. The original statute was written in 1945. Probably almost everyone in the town was going to be receiving a newspaper or going to a store daily to read the newspaper. So it made sense for this to be where the posting of a special town meeting was, and having that additional posting requirement in the newspaper made sense because a special town meeting is special. It happens outside of a regularly scheduled, out of the regularly scheduled meeting cycle. So I think ultimately the legislature should be trying to move more towards taking these newspaper posting requirements and making them requirements on the website, and then allowing municipalities to post additional postings in the newspaper if there even is a newspaper in general circulation. Again, town websites are much more accessible to voters. It's where they're going to find information on town meetings, where they're going to find information on hearings. And to us, it seems like that should be the direction the legislature moves towards, rather than antiquated statutes from the 1940s that require posting in a newspaper, which most Americans and Granite Staters are not receiving their general news on when municipal meetings are happening. And I'd be happy to answer any
Questions
questions.
from the senators? Senator Lang.
So, Brody, the concern always when you go to an online posting only is technology access, especially in rural communities where internet access isn't always great. Would you agree that as a compromise? So in one of the provisions, and I hope it's still law, used to have that you had to have two physical locations in town. Like in my town, it's the town hall and the town library. They put notices up that, oh, there's going to be a meeting. So would you be opposed if we use the idea of saying town website and two physical locations within the town?
Thank you for your question, Senator. And yes, I think that is the direction that New Hampshire should be moving towards. It moves us into the future and meets residents' needs. And frankly, for special town meetings and regular town meetings, we should have those statutes aligned. So for RSA 39:4 and 5, it should be two physical postings and placed on the website. To us, that would seem the most fair and would seem to be the most accessible to voters. And we would be happy to draft an amendment for the committee to review and for your consideration.
Additional questions?
Answers my question.
Okay, seeing none, thank you very much.
Thank you,
Brendan?
senators.
Thank you, Chairman, and thanks members of the committee for hearing me. My name is Brendan McQuaid. I'm the president of the New Hampshire Press Association. I'm also the president and publisher of the New Hampshire Union Leader. we fully support the amendment that was made, and we really appreciate the work that the House Municipal and County Government Committee did on that amendment, because it takes into account the real idea that access isn't noticed. You may see that on the website if you go to look for it, but you didn't know this meeting was happening. And so if you didn't know this meeting was happening, why would you go looking for that information? People aren't necessarily regularly going to seek out that information. And if most towns are like the city of Manchester that I live in, that information could be any one of 12 different websites that they operate. So the idea that the town could place this on their website and not an independent third party, which I will say I did a review when this came up. I couldn't find any of our press association members that put meeting notices behind a paywall. It's very important for us that people know what the heck is going on with their town governments, and we want them to know. So we put that information freely available on our website, and our members do as well, because they want people to know what is going on in their town government. They want people to casually come across this and say, hey, I didn't know there was a meeting going on. I should attend that because this affects our town spending, our town government, how it operates, everything else. Newspapers, where they exist, and I think this is a solid compromise, because some towns may not have a newspaper of general circulation, especially as things go forward, but where they exist, the information should be in there for the town to access. And I'm happy to answer any questions.
Questions from the senators?
So again,
Senator
I think you touched on the end there. My concern is more and more newspapers are going to either weekly, like Laconia Daily Sun just went to Tuesday, Thursday, and it used to be a daily paper. Now it's only 3 times a week.
Yeah.
Versus 7 days a week. My concern, and up north, they have even more papers that go to weekly, or I think the Plymouth Record went out of business. They don't even have a newspaper up there anymore. So my concern is where we put this requirement on communities, and they end up advertising the Manchester Union Leader for a meeting that's occurring in Plymouth, because that's the only widely circulated newspaper in the area, but who's going to actually read it unless they happen to grab the Union Leader on the day that the notice is posted?
Well,
And so I guess that's my concern, is recognizing that our communities are, the print media, I still love a newspaper, don't get me wrong. I love a piece of paper in my hand. But the ability for some of these communities to get that notice out, and the requirement to publish in a newspaper that is to a certain extent irrelevant to their community, but it's in order to meet the state law, they have to do it. So that's my concern.
well, I'll try not to take that personally, that it's irrelevant to their community. The Union Leader is statewide, but I think this does strike a balance, because it says the newspaper of general circulation in the town, which you'll find is different than a lot of the RSAs, which specify county. And so we are a newspaper of general circulation in every county, but we may not be in every town. And I think that is important as things go forward and the makeup of the media changes in the state and around the country, where you have access to that kind of information. But I think that where the newspapers do exist, number one, it's important that they get support and don't take that little bit of revenue that some of these small papers have away from them. Number two, the information should be in there, because when people are perusing that content, which they do, believe me, when we make a mistake, we hear about it. They read every single thing in that paper. And because of that, people then know what's going on in the town. And, I don't want to say that anyone might be a bad actor, but in the spirit of this being Sunshine Week, it's important that that information get out there. And if a town wanted to bury something, it would be very easy to put it and say, well, it was on our website. You just didn't see it that day. So I think it's important that it's in a independently verified third party. All the newspapers provide affidavits that state when it ran, how many times it ran, all that information. So it's verifiable that it actually existed.
And then you have a subscription to the Union Leader, so you're all set.
Additional questions from the senators? All right, seeing none, thank you very much.
Thank you.
There were 2 people that signed up here and have spoken, one opposed and one in support. There were 2 people online that signed up, and one is opposed and one is support. So with that, we'll close the public hearing. We'll open the next one in just a minute. Come on up, Representative. When she's ready, she'll tell me and we'll start right off.
Mr. Chair, would it be all right with you if I hand out my testimony?
Just hand them to him. He'll take care of it for you.
Thank you.
Depending on what day of the week, we have interns from the various colleges
Amazing.
to help us out. All right, Representative, if you'd introduce the bill and yourself.
Thank you, Chairman Gray and honorable members of the committee. I'm Representative Elena Colby. I represent Hopkinton and Bow. And thank you for the opportunity to present HB 1118. It's a bipartisan initiative designed to advance efficiency for local municipal operations. Currently allowable limit to hold on to in your offices for a municipality is $1,500. That is the limit before you can, before you have to remit it to your treasurer for deposit. The premises behind this bill is to increase that limit as it might be a little outdated, as evidenced by the inclusion of the language in multiple statutes of or weekly. It's important to note some of these statutes haven't been amended in 20 years. Since their implementation, municipality fees have increased in taxes and other fees collected by employees and town officials. Vehicle registration costs, building inspections, permits, rec fees have all dramatically increased. The state has also increased numerous fees that are collected at the municipal level. While the adjustments will be too small of an increase, moving from 1,500 to 3,500, that'll be too small of an increase to affect municipalities that are mid-size or larger size. It should really help many of the smaller communities who don't have maybe a bank that are close to them. It'll allow their municipal employees to stay in the office and continue working during the workday, as opposed to having to close up or close early and go make the deposit and come back. I hope
Questions
that is
from the
helpful.
senators? Seeing none, thank you very much.
Great, thank you.
There was one other person that signed up in support, did not wish to speak, and there was nobody that signed up online. So with that, we'll close the public hearing. We'll open the next one as soon as we're ready. All set, Jessica? And we'll open the public hearing on the next bill, 1151, and ask the sponsor to introduce himself and the bill.
Thank you, Mr. Chairman. Thank you, Senators, for the opportunity to introduce House Bill 1151. For the record, my name is Jim Majori, representing the wonderful town of Northampton. And this hopefully will be the simple bill for the day. Doing a little bit of research into a bill about conservation commissions, we realized in RSA 36A5, one, there is a citation that the town and city treasurers have the authority for the funds of the conservation commissions. And then in Roman 2, it goes on to cite the RSA for the town treasurers for that authority, but it doesn't have the citation for the city treasurers. All this bill does is in Roman 2 of the RSA, add the citation for city treasurers, which is found in RSA 4816. Just seemed like it was more administrative than anything else. And with that, that's the extent of the bill, and I'd be happy to take any questions.
Questions from the senators? Seeing none, thank you very much. You're the only one that signed up, and no one signed up online. With that, we'll close the public hearing And I'll take a motion to go into executive session. We have a motion and a second to go into executive session. All those in favor say aye. Aye. All those opposed say nay. The ayes have it. We're in executive session. Now, I'm not going to encourage you to do bills, and I would expect that we don't want these on the 26th, even if we did exec a bill. So whatever it takes to, if we do exec anything, to hold them until after, certainly that's, we don't want the 26th to be any longer than it has to be. Do you want to exec any? I would guess these last two are probably.
I was right there, Mr. Chair. I was ready to make an OTP motion on Bill 1151.
Second.
I have a motion and a second for ought to pass. Any comments?
Nope.
All those in favor of ought to pass, say aye.
Aye.
All those opposed, say nay. The ayes have it.
Move consent.
Is there anybody that objects to consent?
No.
All right, all those in favor of consent, say aye.
Aye.
All those opposed, say nay. And, all right, Senator Long.
I move ought to pass on 11/18.
Second.
Let me catch up with you here. All right, Senator Roachford moved out to pass and Lang seconded it. All right, discussion. Seeing none, all those in favor ought to pass, say aye.
Aye.
All those opposed, say nay. The ayes have it.
Move
Any
consent.
objection to consent?
Nope.
Seeing none, all those in favor say aye.
Aye.
All those opposed, and,
I can take it out.
Oh, you got it? All right.
all right. Senator Perkins Coelho's got that one.
Chairman, I just wanted to bring to your attention that I did have an amendment drafted for 1468 at the request of the prime sponsor, so that's available for you guys to review.
I think I saw something here on my table.
Before we move the motion, I just have a question for
Yeah.
Absolutely.
So as amended, this bill just replaces everything and just adds a new section relative to flood resilience. Is that the way I read this?
Yeah, exactly. The bill amended two different sections, and so instead of that, we're going to leave the existing law alone and just put in the new requirement, which the committee did not seem to have any objections to.
So, Mr. Chair, I'll move on past.
All right, well, let me
Second.
find it first. Must be one that we've already heard. So
It's
it's
from
in
yesterday.
a different folder. $18.68. Right, what resilience? Okay, so let me catch up. Who made the motion about to pass?
I did.
Seconded.
And, okay. And who's moving the amendments?
I'll move amendment 202612221S.
1, 2, 2,
Second.
1, S.
I don't think I need to speak to my amendment as I already have, but happy to answer any questions.
I just wanted to know before I made the motion. That's true, it's good.
Is there any further discussion? All right, seeing none, we're voting on amendment 1221S. All those in favor say aye.
Aye.
All those opposed say nay. The ayes have it. Is there voting now on the bill as amended? All those in favor say aye.
Aye.
All those opposed say nay. Is there objection to consent?
Nope.
Seeing none, all those in favor of consent say aye.
Aye.
And,
I can take that one out too.
oh my goodness,
Jeez.
2 in a row.
I like this trend.
Hey, if you pass good bills, I'll take them out.
Mr. Chairman, are you ready? Are you ready for a motion on 11:35?
Let's see. I got
I am.
11:34, got 11:35.
I am. I'm just not sure it's the same as yours.
Well, we're gonna make, I'll make the motion. I may surprise you.
Oh.
Okay, we have 11:35.
I move ITL.
Second.
Have a motion to ITL. Any discussion?
Chairman, I think that the hearing made clear that while the intent may have been to react to some modern circumstances, the language as drafted kind of tramples on a lot of tradition in New Hampshire. And I'm sure that we can try again if we want to more narrowly come at this issue.
Okay, any further discussion?
And I would echo my colleague, this would have huge ramifications in my part of the world. And although sounds like it's well-intentioned, it just missed the mark.
All right. Seeing no further discussion, motion is ITL. All those in favor say aye.
Aye.
All those opposed say nay. Do I have an objection to consent?
Nope.
Seeing none. All those in favor of consent say aye.
Aye.
And Senator Rhodes for you got that.
Yeah, thank you. I'll take it.
Anything else you guys want to do today?
I'd like to take up 1233 if we can. at least for
12:33,
discussion.
aye.
So, Mr. Chair, my inclination is this bill is not needed. That I think our current 91A provisions and provisions around non-public sessions are clear, and selectmen are, there's training that is provided to them. So I think that the bill is completely unneeded. So I'm going to make a motion of ITL.
We have a motion of ITL, seconded by Senator Long. LA and LO. That's my abbreviations here. So I keep you guys straight.
I thought you were saying.
Further
the song.
discussion?
I will, I think what the Municipal Association brought forward with there is provisions in current law on this, and there is, routine or procedures that should be followed. It sounds like perhaps there may be some instances where entities are not following that. I am happy to relay back to my constituent, there is some probably legal recourse for his issue, and I will be happy to let him know that.
Okay, further discussion. The motion is ITL. All those in favor say aye.
Aye.
Those opposed say nay. Any objection to consent?
No.
Seeing none, all those in favor of consent say aye.
Aye.
All those opposed say nay. And okay. Senator Long. Anything else you want to do?
So I just wanted to have a discussion, not a motion, but on 1369, we heard today the matter of posting a warrant for a special town meeting.
Yep.
I'd like to see if I can work towards a solution to that. I think that I am concerned about the mandatory requirement of posting in papers, especially in our North Country, and diminishing physical copies of papers that are available. But I also don't think that online should be the only way they get access to it. And I like the idea of having those two physical postings that are done in, at my town, opposite a library, and I think the fire department, town hall. And so I think that I'd like to see something move in that direction, but I'm willing to hear from other senators. If I'm going to be wasting my time, then I don't want to do that either.
It wouldn't be wasting your time from my perspective. I do seem to recall another piece of legislation where we did something very similar last year. I don't know what it was, but I'd be happy to look into it. But anyway, I think what you're proposing would be consistent with what we did on the other bill.
The other thing I'm concerned
Senator
about,
Lang
these are.
and Senator Perkins spoken to work on it.
Okay.
The dream.
I'll take the lead. I'll draft it first and I'll send it to you.
Fine.
Thank you.
I can dream that way. All right. Anything else you want to work on?
I mean, I'm ready to act on 1134. I don't know if you guys need to discuss.
Yeah,
it, so-
we have a discussion if we'll make a motion on that one.
Sure.
Yeah.
So, on this bill, I do think there are problems with the way the bill's outlined and worked out. My major concern is unless they notice people in advance of what's going to cross threshold into either, the turning over the tax cap,
Mhm.
and you wouldn't know that until the things are voted on.
Mhm.
People may change their votes based on whether something is going to overturn the tax cap or not overturn the tax cap. In my town as moderator, every 2 articles, we had a motion to restrict reconsideration on it. So it means that even if they did that and they restricted reconsideration, we voted in favor of holding it, and then we get to that fifth warrant article that now it's gonna tip over and someone says, wait, I wanna go back and undo my, reconsider this vote, because I think that maybe we don't put the money into the cyanobacteria and instead put it into
Right.
fixing this road
Yeah.
that we need
Yeah.
instead.
Yeah.
But the restriction of reconsideration would then prohibit that, so then nobody restricts reconsideration, which creates a bigger problem at the end of the meeting for people who may not be around for a vote.
Yeah.
So I'm a little nervous about the way this is written and the way it's processed. At least that's my take as moderator, having run 15+ town meetings.
Yeah.
So I'm leaning down tail myself, so, but unless someone has a different perspective.
Yeah, I would share some of those concerns, deferring to your expertise in the field. I also just worry a little bit about restating how the 10% cap works in a separate section with additional language. It's probably the lawyer in me. But, I think the concerns you raise are very valid.
Certainly, if I were to do this, I would rather the motions of the warrants be sorted by highest dollar to lowest dollar. And as long as that total dollar on all the motions was going to be over the tax cap to require the 2/3 vote or 3/5 vote, whichever. And then as soon as you eliminated enough of them, that you would no longer require vote because you wouldn't be exceeding the tax cap.
Yeah.
So again, that was just a thought that entered my mind as we were going along. But if you're building a new police station or a fire station and that amount, of course, it's going to be capital money instead of the regular warrants, or so pick something else. But again,
Well, that would still go towards, again, if you have a tax cap and the amount of money, so the debt service that would be applied to the bond that's
Would be
going
in
on
there.
would go towards the tax cap.
Yeah.
So it still has to be included in the conversation, even though that bond article in and of itself requires the poll to be open for an hour and a vote, a ballot vote.
But since that has an implication on the rest,
Right.
it might be best to settle the capital thing first so that you know whether you actually have. Anyway,
Again,
there's
so I know
many
selectmen
questions.
do that, when I'm in meetings with them and we're going over getting ready for town meeting, the order of the warrant articles as they appear is a conversation that occurs.
Right.
Because it also occurs in relative to attendance, right? As you put something on later in the night, you start losing voters, and the question,
Right.
let's put the more important objects up front so we get the most possible voters voting on something,
Right.
which may not be necessarily the priority, but it's a matter of having voters. So I guess if I was to make a motion, because I think there is a conversation here, but maybe interim study will be a good, clean way of saying it. We agree with the policy, needs some conversation, but this isn't the way to go about it.
It would be interesting if
Second.
NHMA or somebody could say how many towns this is a problem in. I mean, if it's a problem in one town, then why do it? If it's a problem in 125 towns, if you had the information.
Thank you I'll speak very briefly. I can't put an exact number on it, but what I'll say is that we have not received many legal inquiries outside of from one town, town of Brentwood, that asked some questions to just understand procedurally so they could do it correctly at their most recent town meeting with a tax cap. So they got input from DRA and our legal counsel. And I think the key issue that's been flagged here is by limiting the legislative body's ability to reorder its warrant, it's limiting the legislative body's ability to prioritize what spending it thinks should be prioritized. So ultimately the voters at the traditional town meeting. So while it might seem like, generally it might seem to make sense to put big ticket items first and let the smaller ticket items go later, there are often times where the legislative body says, we don't want a bonded warrant article to take on debt this year. Let's put that at the end. We're more interested in the new position at Parks and Rec. We think that's a better way to spend our money and to have, easy approval under the tax cap or under the 10%. So ultimately our concerns with 1134 still continues to be limiting flexibility.
A little bit beyond the question, Brody, so.
Sorry.
Cut you off.
I'll,
One town.
yes.
question.
One town that has solved the problem. That's the answer, to my knowledge.
Okay,
Mr. Chair, given that, I'm gonna move in on study on this bill.
Second.
we have a motion of interim study made by Senator Lang, seconded by Senator Perkins Coker. Any further discussion? All those in favor of interim study say aye.
Aye.
All those opposed say nay. Do I have an objection to consent? Seeing none, all those in favor say aye.
Aye.
And
I'll take it up.
Senator Lang will take it up. Anything else you guys want to do?
I will just note, Mr. Chair, that I think we passed everything on consent, so I don't know if it matters if it goes to the 26th or not.
It depends on whether anybody pulls anything off. But no, to get them on the consent, if they can get on there, I'm not objecting to it. But don't want to require them on there. All you who have blurbs will have to review them quickly
Yes.
if we do get any of that done.
Mr. Chair, can I talk, just one thing, the bills we've already heard and haven't exec yet, we have two left, 1494 and 1031. 1031, we talked about adding an amendment to for Article number 5 for training. Am I supposed to be chasing down that amendment? If so, I'll make sure we have it for the next meeting. Or is that gonna, who is?
I see, my recollection is you volunteered to do that.
That's fine. I thought so too. I was trying to remember which bill it was until I saw it right here. I'm like, oh wait, I think this is the one I said I'd do the amendment.
You amended my draft that wasn't complete and said, is this good? And
So I will get an amendment drafted for the next meeting for 1031. Is there anything we need for 1494, increasing the maximum amount of optional veterans tax credits? Is there anything pending for that, or is there any reason why we're holding it?
I believe the chair talked about removing the upper limits, and
Well,
I talked about removing the amounts altogether.
It appeared to me that the sponsors say that this was the last one that was going to come in for a while and would just assume the thing go forward. I think if we're going to remove those upper limits, that ought to be a comprehensive bill that does it for all of them. And that, whether it's germane or not, because you're dealing with different tax credits. I guess I support the bill the way it's drafted right now, but I would not be opposed at some point to removing those upper limits and letting the community set their own. Don't necessarily agree with the limits that they're there now. And on the Rochester City Council, I voted against Rochester raising them to the maximum that was allowed in statute. So for regular veterans, not for the disabled veterans, I think that's a completely different category.
So, Mr. Chair,
somebody
given
wants
that,
to
knowing
make a
that
motion.
probably a next year bill that we might take a look at all these credits and just set a floor and let the ceiling be whatever the towns choose the ceiling is to be. But for in that case, I'm gonna make a motion of auto pass on 1494.
All right. 1494.
Pull that up.
All right.
Second.
1494 ought to pass. Senator Lang, Senator Perkins, Woka. Any further discussion?
So I'll just remind you that one of the reasons why this bill is moving forward is because we changed the law last year dealing with the credits and not stacking, and therefore it created some problems for some veterans. And this bill is seeking to fix that.
Okay. See no other comments. All those in favor of auto pass say aye.
Aye.
All those opposed say nay. Any objection to consent? Seeing none. All those in favor of consent say aye.
Aye.
And Senator Lang wants that one.
Thank you, Mr. Chair.
Good work, crew.
All right. Anything else you want to do? Seeing none,
Move to come out of
we have a motion to come out of executive session. All those, we have a second? Yes, we have a second. All those in favor say aye.
Aye.
All those opposed say nay. Ayes have it. And our business of the day being complete, we are adjourned.
Thank you, Mr. Chairman.
Hey, we're in good shape.